Non-scheduled injuries. Some types of injuries are unique and complex. These are not addressed under state scheduled injury statutes, but instead are addressed individually in their own statutes. Common non-scheduled injuries include psychological injuries, hernias, occupational diseases, and repetitive trauma. Psychological injuries. Psychological injuries are particularly hard to prove because they often have no visible symptoms or clear onset date. Their supporting evidence is subjective, and they likely may have multiple causes. To address psychological injuries, jurisdictions often divide them into 2 and sometimes 3 separate categories: physical-mental, mental-physical, and mental-mental. Physical-mental injuries. Physical-mental injuries occur when a worker has a physical injury that causes a mental condition. Examples include where a prison guard is beaten by prisoners and therefore develops a psychological condition, or anxiety and depression resulting from a work-related back injury. Physical-mental injuries are often compensable. Some jurisdictions even allow recovery for physical-mental injuries if they result from normal rather than unusual work conditions. Mental-physical injuries. Mental-physical injuries occur when a mental stimulus causes a physical injury. They are not as easy to prove as physical-mental injuries, but are more likely to be compensable than mental-mental injuries, discussed a bit later. Examples include fright by nearly avoiding an accident or by witnessing something traumatic, which then causes the employee to suffer heart attack, ulcer, or stroke. Mental physical injuries are likely compensable, so long as the work-related stress was unexpected, unusual, or the result of extraordinary employment conditions. If the physical injury was caused by stressful work conditions that were the normal, reasonable conditions of the employment, however, the injury is generally not compensable. Mental injuries. Mental injuries occur where a mental stimulus causes psychological injury, and they are the most difficult to prove. Examples include where an employee suffers emotional distress caused by continuing on-the-job harassment by the employer, or where a worker witnesses a coworker fall to his death and subsequently develops the disabling fear of heights. A minority of states, including Alabama, Florida, and Georgia, bar recovery for mental injuries altogether. However, most jurisdictions recognize mental claims as compensable, but may apply additional requirements beyond those for mental physical or physical mental claims. States that allow compensation for mental claims generally fall into 3 categories. First, a small number of states have historically provided compensation for mental injuries without imposing any additional requirements. Second, states including South Carolina, Maine, and Vermont allow recovery for mental injuries only if the injury was caused by extraordinary or unusual conditions of employment. If ordinary and usual circumstances caused the mental injury, there is no recovery. Third, some states such as Colorado and Louisiana require that the medical stimulus be a sudden event. If the mental injury results from gradual exposure, then it is not compensable. States may also limit recovery for mental claims in other ways. For instance, in California, the worker must have been employed for at least 6 months prior to the injury for a mental injury to be compensable. Several states also explicitly deny benefits for mental injuries if they are caused by non-discriminatory, good faith, lawful personnel actions, including discipline, demotion, and termination. Hernias. As with psychological injuries, states often apply extra requirements for compensability for hernias, as compared to regular scheduled injuries. These extra requirements are intended to ensure that the alleged work incident caused the hernia. For instance, South Carolina requires that the hernia appeared suddenly and immediately following the work-related accident, and that it was accompanied by pain. Pain does not include general symptoms of fatigue, and it must accompany the accident that causes the hernia, not a hernia when it subsequently develops. The court has used pain as an indicator of the actual onset of the hernia. North Carolina requires that the hernia or rupture was not pre-existing, but does not require that the rupture immediately follow the accident. Instead, the hernia only has to be the direct result of the traumatic incident. In contrast, Maryland law does not require that an accidental injury cause the hernia, but it is enough if the hernia was caused by a mere work-related strain. Some states limit compensability by imposing strict timeframes in which an injured worker must notify the employer that he has suffered a hernia. For instance, Maryland requires notification within 30 days, but New Jersey requires notification within just 48 hours. Hernias are also unique injuries because they generally require surgical repair. In some states, an injured worker must undergo surgical repair. Otherwise, no benefits will be paid unless and until he complies. There usually is an exception if the worker has some condition that makes surgery unsafe. If the injured worker dies in surgery, the death is considered a result of the work accident. Therefore, death benefits are payable. In other states, a worker does not have to undergo surgical repair to receive benefits. However, even where the worker does undergo surgical repair, there is no presumption of permanent disability. Instead, the worker must prove the extent to which he is permanently disabled, if at all. Occupational diseases. Disease is defined as any deviation from the normal and healthy functioning of the body. Generally, states define injury or injury by accident as excluding all diseases except two types: those resulting naturally and unavoidably from the injury by accident, and those considered occupational. An example of a disease that results naturally and unavoidably from the injury would be where a worker continues to have arthritic pain in his knee following a specific knee injury. This section will focus on occupational diseases. Occupational diseases result from exposure to particular substances at or debilitating conditions of employment. They usually occur only after long periods of exposure, rather than after one specific incident. This is how they are distinct from the usual injury by accident under workers' compensation law. However, they are compensable nonetheless. States vary, however, as to what occupational diseases are compensable and as to what special rules or requirements may apply. Heightened causation requirements. Some states mandate that a claimant with an occupational disease must meet heightened causation requirements, including that the disease is characteristic of or peculiar to the worker's employment. In these jurisdictions, an occupational disease will not be compensable unless the worker shows that the disease is a common occurrence in the employment, even if it in fact resulted from exposure at the workplace. Along similar lines, some jurisdictions apply the greater risk rule, which requires that the employment subjected the worker to a greater risk of illness than the general public. It ensures that ordinary diseases of life, those to which the general public is equally exposed outside of employment, are not compensable. An example of a disease that meets the greater risk rule would be